Hi, my name is Nick Mendoza. I'm a attorney at Murphy Anderson in Washington, D.C. I primarily represent False Claims Act whistleblowers and other whistleblowers under different federal laws and programs. And I'm here with.
Peter Katz. Nice to see everybody. I have my own law firm, the law offices of Peter Katz. I'm in New York and New Jersey. I also handle False Claims Act and whistleblower cases, but I also have another life where I do a lot of federal and state criminal defense work. And so, as a former state and federal prosecutor, I have a kind of experience on both sides of the aisle there.
So, Peter, when you were a prosecutor, did you work with whistleblowers?
I did. In fact, that's how I first became aware of the False Claims Act and Ketam cases when I was a federal prosecutor in New Jersey about, probably 20 years ago or so. I had a criminal case that came into our office through what I didn't know what it was called at the time, but it was the Ketam complaint. I had an agent from HHS, Health and Human Services, came to me with a case that looked like every other criminal case I had handled, but it came through a Ketam filing, and that's how I first became aware of it and started handling the case on the criminal side as it related to that False Claims Act case that had been filed on the civil side.
And how did working with the whistleblower, how did that work from the criminal side?
So in that experience, I actually never spoke with the whistleblower himself. Part of that was because he was severely disabled. And so there was an issue just communication wise, but I dealt extensively with his attorney. In other cases, I've sat down and spoken directly with whistleblowers as a prosecutor and interviewed them kind of the same way you would handle an interview, or just a typical relator's interview.
So, we both represent whistleblowers, and oftentimes when someone comes into a whistleblower lawyer's office, they have a lot of when they want to blow the whistle on someone committing fraud or another crime. They have questions about what will happen on the criminal side. They want to know, is someone going to be is the person they're reporting going to be criminally prosecuted? Will they go to jail? And what would the other consequences like that be from blowing the whistle? So what kind of questions do you get like that, and what do you say to these whistleblowers?
Sure. Yeah, I often, as you probably do too, as you just mentioned, a lot of people are inquisitive about that. They don't know. So a lot of people who are whistleblowers, they're trying just to do the right thing, right? They're not even in it because of the False Claims Act. Many times they come to us, they don't even know what the False Claims Act is. They just know there's an issue and they want somebody to help. But even if they did know that it exists, they're also going to ask that question, well, what's going to happen to this person or this company? And that's a legitimate question, and it's one that I get very frequently in one form or another. As far as what I tell folks is, hate to sound too lawyerly, but it depends, right? It really depends on the situation, and it's hard to generalize. But um, uh, I tell them that the government is going to look at this case, they're going to look at the fraud, and they're going to decide whether or not this is going to be prosecuted criminally or whether it's going to be handled civilly or both. And it's really hard to know upfront which one of those things is going to happen. And as we have our discussion, we can talk about kind of what those different things are. But I'll have that initial conversation and let them know that it is a possibility depending on the situation. And you typically will see it more when you're dealing with someone reporting or blowing the whistle on an individual or a smaller practice than, let's say, a large pharmaceutical company or something like that, when it's more personal rather than institutional.
Yeah, let's talk a little bit about the differences between types of defendants, types of people that are being reported on. What are the reasons that there are differences in how criminal goes after different types of defendants?
Well, as you know, many of our cases are brought with the federal government through the Federal False Claims Act. So I'll deal with that. Each state will be a little bit different for the states that have False Claims Acts as well. But in the federal system, there have been over the, I don't know, last 15 or maybe even longer, 20 years, memos that have been put out by the Deputy Attorney General or the Attorney General in some instances about how to treat individuals and institutions, corporations, when it comes to criminal sanctions or civil sanctions in the whistleblower realm, in the False Claims Act realm. So the Department of Justice has set up different guidelines about when somebody should be prosecuted, when a corporation should be prosecuted. And lately, we're doing this in November of 2025. The Department of Justice is very much looking to hold individuals accountable. It's not to say that they won't prosecute corporations, but I think that they're much more focused on individual responsibility and holding individuals responsible. So that's how they're going to that's the lens that they're going to use as they make that determination.
Hmm. What about sometimes I think people are worried that they're reporting on a company or a group of people, and they think that some people are more culpable than others, or they think that someone was really the leader, but they're the leader of the fraud, and they're worried that other people who maybe they're friends with or they have more sympathy for are going to get caught up in the investigation. What kind of guidelines or distinctions does the government make in that kind of situation?
Yeah, it's a good question, and it's a difficult one to answer. A whistleblower comes to me and talks about that. It's hard, and sometimes it even bleeds into the whistleblower themselves, right? They may be somehow involved, maybe tangentially, maybe they know about it or saw it, and from a criminal liability theoretical perspective, that makes it a more complicated conversation. Like that can happen, but if it's for we're talking just about other individuals. I tell whistleblowers it's difficult. Once you blow the whistle, you don't have control over exactly where that investigation is going to go. So you really don't know where it's gonna lead to. That said, the government is interested in stopping the fraud, and the way you stop the fraud is by going after the people who are primarily responsible for it, and not people who are kind of on the fringe or on the outside. That's not to say that those people may not be contacted. It may not be that those people don't have some what we call exposure, criminal exposure. That's possible. Again, very fact specific. It depends. You can put that in quotes and put it up on the screen because it's really very true. It's very case specific. But I would tell the potential whistleblower that you don't know what's going to happen. But the focus of the government is to recover those funds and to hold the people accountable who are really responsible for the fraud.
Right. And you mentioned sometimes the potential whistleblower themselves might be implicated or might be worried that they're implicated. How do you go about advising them on that?
It's a difficult conversation to have. The first step is kind of understanding what the story is, right? What fraud are they reporting? Who are the players? What is their involvement? And trying to go through that, having working with and having worked with many people who are charged or under investigation as well, kind of have to ferret out that information a little bit differently than you might in a whistleblower who clearly has no involvement in whatever the fraud may be. So you have to kind of make sure you understand the lay of the land and educate yourself on the facts. And then sit down with them and kind of really go over with them what the possibilities are, right? Are they, maybe better off not even coming forward, which I've advised clients, you're better off just sitting back. One anecdote I'll tell you, literally this just happened a couple of days ago. I had a call from somebody, he just found me on the internet, described what sounded to be like a very good False Claims Act case. In fact, he mentioned that there was already a criminal case pending, but he was the source of that criminal case. And I was like, great, this looks like a great client. And then within, I think, an hour or two, I had calls from a detective saying that he was actually a suspect and was supposed to report that very day to turn himself in the exact same thing he was reporting. So an extreme example, but one that does happen on occasion. Not the typical person, not the typical situation, but you need to sit down with folks and let them know kind of the reality of what the possibilities are, and then they'll make a decision about how to go forward. I will say, it's not typical that someone who's a whistleblower is going to be charged with a crime. Very, very unlikely. That's the extreme example. But yet you still want to be careful. Typically, there'll be people who are on the fringe of the fraud. They have to know it somehow, right? They maybe saw it, or maybe they were a low level person and knew about things that were up the chain. And what I tell people is that the government is typically not looking at the low level people in something like that. They're looking to get the people who are in charge of the fraud, who are going to benefit from the fraud. And like the old from the movie All the President's Men, Watergate movie, follow the money, right? So they'll follow where the money goes. And those are the people, the ones who are going to benefit, are typically the ones who are going to become the criminal targets.
Right. And there's nothing and certainly in the primary law we're talking about, the False Claims Act, there's nothing stopping someone from suing under that law, from bringing a whistleblower case under that law if they're like that, like you say, on the periphery, or if they have some involvement in the fraud. Really, the only the only time that it might matter is if they're really at the center of it, or they're a primary leader or instigator.
Correct. I mean, if they're on the fringe, I still would have a conversation with them about there are some provisions in the False Claims Act about the percentage of the award that they may be able to get. I don't know what get too deep into the weeds of the nitty gritty of the False Claims Act here, but it might affect what the award would be. But if they're on the fringe, kind of your typical situation, probably not going to be an issue from a criminal prosecution standpoint, or affect their potential award on the back end.
So let's talk a little bit about the Department of Justice and the U.S. Attorney's Office. How are U.S. Attorney's offices? You know, they have both a civil and a criminal side. How is that organized, and how do cases, joint cases, work in the U.S. Attorney's Office?
Sure. As you know, there are, I think it's 93 different districts around the country. And each district is kind of it's its own office and its own fiefdom, and has its own kind of history and cadence and style. So everyone is a little bit different. So again, I'll go back to my old friend. It depends where you are, which district you're in, but they all are structured the same way. There's a criminal division and a civil division. And those two things are separate. Civil AUSAs, or assistant U.S. attorneys, and criminal AUSAs do different things. Obviously, the criminal ones handle criminal cases, the civil ones civil, but sometimes they overlap. Like in the False Claims Act, when we're talking about fraud, there's a lot of overlap there. Um, Typically, what will happen when a case comes into the typical U.S. attorney's office, someone in the civil division is going to review that on the civil side, and they'll take a look and they'll see, and they'll make an initial determination of whether or not they think it might be criminal in nature, right? Not every single False Claims Act case is criminal, but many of them could be, and they'll use their discretion and their own internal policies to decide whether or not they're going to kind of let criminal even know about it. Some offices, all of the cases go to the criminal side. Some other offices, they make determinations ad hoc for each case. Once that happens, if they do want to bring in the criminal folks, the criminal AUSAs will take a look at it, and they may work together initially. And even, in a typical False Claims Act case, there's the relators meeting, right? They're going to go and do a relators interview. So the whistleblower is going to come in and be interviewed by people in the U.S. Attorney's Office. If criminal is involved, they'll probably come in and sit in on that meeting, because they're going to run two separate parallel investigations. There'll be the civil investigation and the criminal investigation, but those can overlap in a lot of ways. And for purposes of saving resources and consistency and time, they'll often do things together that they can and are legally allowed to do together, like interviewing somebody. So they'll do that together. They'll make separate decisions and determinations about whether the case is going to be criminal or if they're going to intervene in the civil side, but they'll do as much as they can together, again, for efficiency's sake. There are some things, though, that the criminal folks can do that the civil folks cannot. And that includes the use of a grand jury. And people have probably heard a lot about this recently in the news, but grand juries are criminal investigative bodies that are run by the courts that the U.S. attorney's offices and the AUSAs bring evidence to. They can subpoena documents, they can subpoena records, they can subpoena people to come and testify. So they have a lot of powers. One of the provisions of federal law is that everything that happens in the grand jury, even the documents that the grand jury subpoenas, are secret. And it's very hard to undo that. We just saw just yesterday or 2 days ago, we saw regarding the Jeffrey Epstein case that Congress had to pass a law to allow the Department of Justice to release these materials that would otherwise be restrictive under federal criminal rules. So usually the criminal and civil AUSAs will coordinate so that they don't have to use a grand jury subpoena to gather information, because if they do, all of that information has to be walled off from the civil side. They're not allowed to see it, even though they're in the same office. It seems kind of strange, and when you first tell people about this, they don't really understand why. The law is the reason why. The criminal AUSAs are, by law, have to keep it separate. So they'll try to do as much as they can together. They'll try and get information with through other means like administrative subpoenas or what are called CIDs, civil investigative demands that can be handled by both the criminal and civil folks. So they'll try and work together as much as they can. If criminal is going to go get more involved and they have to do things in the grand jury, like they're going to go indict somebody or charge somebody with a crime, they'll have to do that separately, and the civil folks won't be a part of that part of the process.
Hmm. How common is it for a whistleblower to have to testify before a grand jury?
Uh, I've never heard of it. Part of the reason is grand juries are secret, so it's hard to know exactly who testified in it. But more practically, and from my experience as a prosecutor, it's not necessary, because a federal grand jury, while they have to present evidence, they can present hearsay evidence, meaning they can have one person testify about what somebody else said. So in almost every single federal criminal grand jury proceeding, it's what we call a summary witness. It's usually an agent, what we call a case agent or a special agent, who will come in and summarize all of the evidence that they have. And for that reason, they can use that to get the indictment. They don't need to put live witnesses in, and that would include someone like the whistleblower, even if the whistleblower is a prime or a critical witness.
So, when a criminal case is being brought based on a False Claims Act case, how does that affect the False Claims Act case itself? Like, does it slow everything down, or are there priorities that matter?
Yeah, that's a good question, and one that comes up quite often when there are these parallel investigations. When I first started, I used to think it was great to have the case go criminal, right? I'm a former criminal prosecutor, right? So I'm like, okay, of course, everything should go that way. But as we'll discuss, it's not always that case, not always that way. And here's part of why. When the criminal case happens, the civil case or the False Claims Act case almost always gets stayed. What does that mean? Halted, just stopped. And it has to take a pause while the criminal case is going on. That's because of the way the statutes are written. The criminal case takes priority for a variety of reasons. And so the criminal case has to wind through its process before the civil case can kind of ramp up. Now, there can be some benefits for a whistleblower in that instance. Number one, obviously, the U.S. Attorney's Office thought the case was important enough to actually charge somebody with a federal crime, which is very serious. And so that means they take the False Claims Act claim that the whistleblower brought forth very seriously. Number two, it also means that it's much more likely that there's going to be some type of positive resolution with regard to the people who committed the fraud, right? Because just statistically, I think it's something like 98 or 99% of people who are charged federally with a crime are convicted. And so a lot of whistleblowers, one of their main concerns is that the people are held accountable. That's certainly a way to be held accountable. And so that's very beneficial, but it does slow down the process. And as I think we'll discuss in a little bit, it also causes some wrinkles with regard to any monetary award that the whistleblower might be eligible for.
Hmm. So, right. So, as people may know, the our criminal justice system involves very few trials, and as you say, almost everyone who's charged with a crime is convicted or is reaches a plea agreement. So, since trials are rare, how, but people may still be thinking about a trial, and that they might have to participate in a trial someday. What do you think about that? What do you tell people about that possibility?
Sure. I talk to people about that kind of in the same vein as I talk to them about whether or not someone's going to know that they are the whistleblower, right? That's often a concern about are they going to have anonymity? And what I tell them is that we cannot assure that they're going to have anonymity. Obviously, if the case goes criminal, there's no way to guarantee that at all. Um, but it's also unlikely that people are going to find out about anything about this person other than the case going to trial or it having some other criminal resolution. So, but specifically to your question about the criminal side, what's going to happen? Are they going to have to testify? Again, it really depends. If they're an insider who has really critical information, the government may see them as a critical witness, as we talked about before. They have a kind of someone who can really help tell the story, and then they may have to testify in a criminal case. It's really unknown whether that'll happen. But as you said, it's unlikely, not the typical situation, but it is something that they have to be prepared for that is possible. And the kind of difference between the criminal and the civil is once the case goes criminal, that person, the whistleblower, wouldn't necessarily have a choice about whether they testify or not. The government can subpoena them and force them to testify. In a civil case, they've brought it, if really push came to shove, they could just dismiss the case if the government hadn't intervened and taken over, and they can really kind of decide to abandon ship. That's really not an option in a criminal case if the government wants them to testify.
Right. So the so as you alluded to, as the way false claim the way the False Claims Act works is you file a lawsuit against someone who you allege committed fraud, and if the government intervenes and takes over the case and settles or litigates the case to judgment, the whistleblower gets a percentage of the recovery. So how does the percentage, the whistleblower's bounty, how is that affected by a case going criminal?
It's a good question. So the first part, which isn't directly about how much money they're going to get, but still relevant here, is the fact that the case goes criminal is probably a good thing because if there's a conviction, which again, as we discussed, is pretty likely if the case has been brought, it means that they're almost automatically going to win the civil case because the burden of proof in a criminal case is higher than it is in a civil case. So if the government is able to prove beyond a reasonable doubt that someone committed this fraud, it's very, very, very likely, almost 100% likely, that they're going to be able to prove that whatever the claim was in the False Claims Act case was proven to a preponderance of the evidence. So just on the front end, it's very beneficial because it means you're very likely to win. Now, as far as recovery goes, again, when I first started this, I thought, oh, that's got to be great. Case goes criminal. It means they collect all this money, and now I'm, almost guaranteed to get, the kind of my full share. Not quite so fast because with criminal cases, there are different ways that the government can collect money from the bad guys, right? In the typical False Claims Act case, if it's just a civil case and there's a settlement, let's just use round numbers, it's $1 million settlement, the whistleblower will be entitled to typically somewhere between 15 and 25% if the government intervenes in the case, if they take it over. And so they're going to get between $150,000 and $250,000 because all of that money is going to come into the government through the False Claims Act itself. If there's a parallel criminal case, it muddies up the waters with regard to how the money comes into the government. And how the money comes to the government is really important in determining how much of that money is then awarded to the whistleblower. And I talked about the different districts. Every district treats this a little bit differently. There are laws that talk about it, and the criminal proceeding when the money's come in, it's called an alternate remedy provision of the False Claims Act. Again, without going deep into the weeds of it, the way the money comes into the government can affect how the government doles out those funds and which monies get counted to determine the whistleblower's percentage of award. So, for example, in a criminal case, there are really three different kind of buckets of monies that come into the government through a criminal case for our purposes here. One is there could be a fine, right? The person or entity could be fined because as part of a criminal sanction. They could have to forfeit certain funds that they recovered, what's called asset forfeiture, and they could be ordered to pay restitution or pay money back. In this case, in a typical healthcare or Department of Defense type of procurement case, it would be money going back directly to the government. Um, and so those three buckets are treated very differently when it comes to, well, what's that mean for the whistleblower? If there's a fine that's paid, the whistleblower across the board is not going to get any share of that. That's a fine that goes right into the government. If it's asset forfeiture or restitution, it's much murkier. And it really depends, again, it depends on the district, on the AUSA that you're dealing with, the judges that you're dealing with, and kind of exactly how the money came in. Just one anecdote. I have one case where the case did go criminal. It stayed criminal for a very long time. There was a conviction, and there was a resolution, kind of a global resolution. So they resolved both the criminal and the civil False Claims Act case at the same time. And they basically divvied it up. And they said half the money is going to be allocated for criminal restitution, and half the money is going to be for the False Claims Act recovery. And this is kind of made up, right? I mean, there's really no exact science when it comes to this. So it's very case specific, fact specific, and office specific. In this case, I was worried, okay, they're going to say half is criminal and half is False Claims Act. Does that mean that our award is going to be cut in half? And in some districts, the answer would definitely be yes. I've heard many stories from colleagues where that's happened. In this case, thankfully, we're in a district where that isn't the case, and the office specifically said they're going to consider the criminal funds that came in through restitution in considering the award for the whistleblower. So we got lucky, fingers crossed it's not resolved yet, but it looks like that's how it's going to go. And so that's kind of the dance that as a False Claims Act attorney you have to deal with, kind of the nuances of the law and dealing with both parts of the U.S. Attorney's Office in trying to get the best result for your client there.
And that's certainly knowing which district has which policy and how you might be treated differently depending on where you file the case. That's certainly something that a good False Claims Act attorney can be expected to know and advise you on as a whistleblower.
Yeah, definitely. I think that's right. In this case, it's a little bit difficult to know because you'd have to kind of foresee whether or not they're going to bring the case criminally or not. But just as a general notion, that may influence where you're going to bring a case. If you see a case and say, hey, my spidey sense tells me that this is going to be a criminal case or has a good chance of it, let me try and go someplace if I can to an office that's more receptive to the arguments and to the example that I gave rather than one where there's going to be a limitation on what the whistleblower is going to be entitled to recover.
So I just wanted to go back briefly to the start of your answer, which was about how going criminal will affect the resolution of the case. You talked about the different burdens of proof, and actually, the False Claims Act even has a provision that lets you bring in criminal judgments to help prove your case. So does that mean that the case going criminal is necessarily going to speed up the process once the conviction is reached and the criminal case is over?
I'd say yes and no. The fact that the case went criminal, let me say this, criminal cases tend to proceed more quickly than civil cases as a general nature. So if they both are starting at the same time, in the same pace, the criminal case will get to resolution in a typical situation much quicker than the civil case will. Okay, so that does speed things up in one regard. But on the other hand, because of some of these other issues that we're talking about, trying to figure out if there's a parallel resolution, that's going to slow things down. If we might have an administrative aspect to it, that may slow things down as well. There's going to be discussions about kind of the split of how the finances are going to work. That may slow things down. So while yes, it'll speed it up in the front end, on the back end, it might make it a little bit more murky. And when things are murky, they tend to slow down quite a bit. And that makes it a little bit more difficult. So in my experience, again, when I first started, I thought going criminal, yeah, that's great. It's going to go a lot quicker. Not necessarily.
Right. And another consideration is that you're bringing a civil case against someone who now very well might be in prison, and so the negotiating with someone in prison, because most of these cases that go well are settled either by the government or by the whistleblower themselves. It's a little harder to negotiate with someone who may be in prison.
No question. I will say this though, for most of these cases, right, these are non-violent cases, and I, I can't think of an example where the case has been pending while the defendant, the target in a criminal case, is sitting in jail. So it may result in them going to jail, but typically while the negotiation is going on and the cases are progressing, they're typically out on the street. And so you usually don't have that. You have the pressure of them having to go to jail in the future, which raises the ante. In some ways, it's also good for the civil litigants, right? Because they're going to be more concerned about the going to jail than they will the monetary aspects, penalties that they may be facing in most situations. I've had some people who are more worried about the money than they are going to jail. The other thing is in federal court, in federal criminal court, when someone pleads guilty or has a negotiation, it's not a negotiation for the amount of time that they're going to serve. They actually don't know how much they're going to serve when they first plead guilty. It's not until their actual day of sentencing that they find out what the sentence is. This is kind of the flip or the reverse of what is most people think of and what is typical in most state court cases. But in federal court, criminal defendants don't know their sentence until the day of sentencing. And so if we're talking about two parallel cases, a criminal and a civil, and he's pleads guilty and there's kind of this joint resolution, that resolution is actually going to happen before that person even finds out whether they're going into jail. So in a typical case, they're not going to be sitting in jail and you're going to have to negotiate with them. But that kind of aura and that the concern of going to jail is definitely going to be over their head. No question about it.
Right. And the some of the other questions we were talking about when we were talking about the recovery and the reward, that might also be resolved on the same day as the day that the person is sentenced, right? Because a restitution order it might go out on the day of the sentencing, so there might be.
It will be the same. The technical order will go out that same day, but typically that restitution amount is going to be negotiated and agreed upon by the parties. And in federal criminal cases, much like civil cases, there can be an agreement about what the restitution is. In theory, the judge could overrule that. Doesn't typically happen. And so it can all kind of be worked out ahead of time, even though from a technical standpoint, the restitution isn't ordered until that point, and maybe payment is structured in some way for after that point. But typically that will happen in the negotiation process before sentencing.
And will the judge? How common is it for the judge to know about the False Claims Act case that might still be under seal?
Well, if it's a criminal case, it's a good question. There's no requirement that the judge know about it, but I think in most cases, the prosecutors will let the judge know. And if there's going to be a resolution, kind of a joint resolution involving criminal and civil, obviously that's going to come to light as well. And so they'll be aware of that in the case. I think for the judge to know about it, doesn't even have to be unsealed. The judge, as part of the judiciary, can just know about it and can work through that process with both the criminal and civil cases.
Mm-hmm. So I guess sort of a final question. You've talked somewhat about your own journey and starting out thinking that a criminal prosecution was a good thing for the case always, and maybe changing your mind a little bit about that over time. When today would you still think it's a good thing, and under what circumstances would you think it's a good thing that a case is likely to go criminal, and when, if ever, would you be these days rooting for a case to go criminal?
Well, I think those are kind of two different questions, but let me say this. When you're looking at these cases and you have somebody come into your office, typically that person, as I said before, is not in it for the money, right? They want to right the wrong that they're aware of. They probably have either gone in, inside the institution, inside the company, the business, spoken to the owner, operator, whatever it may be, and they've tried to make change, and they haven't had success, and so they have to go outside the organization to get that change. And so most people are looking for a positive resolution to, make the fraud stop and to hold the people accountable. So from that perspective, if a case goes criminal and it really is that egregious, right, and the government agrees that it's that egregious, in my experience, whistleblowers are happy with that resolution, right? And so even if it has these other kind of collateral consequences, I'll call it, with regard to an award and timing and all the rest, whistleblowers tend to be happy because justice was done and they feel vindicated for what they have reported and initially had been rejected. So from that perspective, every case should go that way. From an attorney perspective, if every case goes criminal, it means I've picked the right cases to bring, right? And so I've chosen cases that are very strong, that show real fraud, that have a lot of evidence behind them, and are meaningful in some way, whether it's monetary or maybe policy wise or what have you. So also from that perspective, you want cases to go criminal. Just kind of validates that you're looking at the right cases and bringing the right cases forward to the courts and to the prosecutors. On the other hand, when you talk about kind of the financial aspects of it, as we discussed, it's a little bit more of a gray area, right? It still has its positives because it means that a positive resolution is on the horizon, but it may make that horizon a little bit farther away than it would have been if the government chose to only bring the case in the civil arena.
Okay. So, are we forgetting anything? Any thoughts that we didn't cover?
I think we got it.
All right.